This podcast is a production of Widener Law Commonwealth in Harrisburg, Pennsylvania. For more information, visit commonwealthlaw.widener.edu/podcast. Keeping up with the latest legal thinking can be challenging. Our educational programs help you stay tuned into the legal profession. The following is a recording from the 2019 John Gedid lecture series entitled The Administrative State Under Siege. Now here's Dean Christian Johnson to introduce the director of the Law and Government Institute, Commonwealth Professor of Law, Jill Family.
Welcome to Widener University Law School, Widener University Commonwealth Law School, excuse me. It's a pleasure to see all of you here for our 13th annual Gedid lecture. Before we begin, I'd like to ask John Gedid and his lovely wife Carol to stand just for a second to be recognized. Jill family is going to recognize him again in a few moments, but this is the 30th year from when Dean Gedid opened up the law school, and it's a very important anniversary for us. But I know it took him a couple of years before that to get everything in place, but we owe a great deal to John Gedid as our founding dean here at the law school. I'd now like to turn the time over to Professor Jill Family, who's the director of our Law and Government Institute here.
Good afternoon. Thank you to Dean Johnson, my fellow faculty colleagues, all of the alumni that are here, the Widener Commonwealth students who are here as well, administrative law. I see a lot of friendly faces. We actually have administrative law in this room because there are 100 students in administrative law this semester. And as we're about to hear, there's good reason for that, because administrative law is really in the news, cutting edge, and at the forefront of much of what is going on in the political sphere. So welcome to the 13th annual Gedid lecture. This lecture honors John Gedid, who, as Dean Johnson said, is one of the founders of our law school and is also the founder of the Law and Government Institute. These lectures celebrate government law as well as John Gedid's enthusiasm and support for our law school and for legal scholarship. The Law and Government Institute is all about public service. The Institute is dedicated to the study of government law, including the role of lawyers in making and implementing law. At Widener Law Commonwealth, students may earn a certificate in government law in addition to their JD. Government law is fused into our curriculum at Widener Law Commonwealth. The Institute's mission is founded on the idea that government works and that government is a positive force in our society. At Widener Law Commonwealth, we train lawyers to be a part of that positive force. So again, I want to thank you all for coming, as well as Sandy Grafe, who you probably saw on your way in, who is so instrumental in helping us put these events together, Brian Fernbaugh as well as we have our Patrick Murphy Fellows here, Kim Creech and Lindsay Eisinger. I saw her earlier. She's up there. And we're so glad that John and his wife Carol are here for us with this afternoon. And every year we give John his binder back. And his binder is a binder that holds flyers from each of the now 13 Gedid lectures, and we have the Gedid lecturer sign their flyers. So he has signed flyers from all 13. So Professor Metzger was kind enough to sign hers, so I'll give that to John as well as a little present for And now it is my pleasure to introduce you to our speaker. Gillian Metzger is the Stanley H. Fould Professor of Law at Columbia Law School, where she is also a faculty co-director of Columbia's Center for Constitutional Governance. She writes and teaches in the areas of administrative law, constitutional law, and federal courts. She is one of the most prominent administrative law scholars in the country. She has specialized her research on separation of powers and federalism. She is a co-editor of Gellhorn and Bice's Administrative Law Casebook. Her recent law review publications have appeared in the Harvard, Michigan, and Yale Law Reviews. Professor Metzger currently is a member of the Governing Council of the American Bar Association's section on administrative law and is Senior Fellow of the Administrative Conference of the United States. She served as a law clerk to Justice Ginsburg on the U.S. Supreme Court and Judge Wald on the D.C. Circuit Court of Appeals. Please join me in welcoming Professor Gillian Metzger.
Thank you. I'm delighted to be here to talk with you today, and very honored to be asked to give the Gedid lecture today. I looked at who had given it in those past 13 years, and this is putting me in some pretty impressive company. You've had a number of really great scholars on administrative law, so I'm hoping this is going to live up to the prior billing, but we'll see. I'm also particularly glad to be speaking through the auspices of Widener's Law and Government Institute, which was founded by John Gedid in 1999. I, these days, often say to my administrative law colleagues that whatever we think of the Trump administration's policies, we have to acknowledge a debt of gratitude because they have made administrative law the course to take and made us much more relevant and cool than we ever were before. I do feel compelled to say that the only other course that kind of rivals administrative law these days is immigration law. And as many of you know, Professor Family teaches both of those, so she is clearly the coolest cat in this crowd. But at any rate, I'm impressed that way before the Trump administration or the Obama administration made administrative law and government law so au courant that you founded the Law and Government Institute here. The Trump administration provides the backdrop for the subject of my talk today, the administrative state under siege. Early on, the Trump White House proclaimed that the deconstruction of the administrative state was one of its main objectives. And it has followed through on that promise on many fronts. Some examples include a number of efforts at regulatory rollback, including President Trump's 2-for-1 executive order, which requires agencies to repeal 2 regulations for every new regulation promulgated, also prohibits imposition of new regulatory costs. There's also were initially significant regulatory rollbacks secured by virtue of the Congressional Review Act, which was called into service pretty much for the first time ever successfully to repeal a number of Obama administration major rules. And agencies have undertaken significant regulatory repeals since then as well. The Trump administration has also proposed slashing a number of agency budgets, sought to reassign career officials, and in many ways remake the permanent civil service. It has indeed declared war on an amorphous bureaucratic deep state, particularly associated with law enforcement and national security agencies. And it has successfully added to the federal bench a number of judges who oppose administrative governance and have more ideological opposition to administration. This administrative rollback has not occurred, of course, across the board. Agencies that serve the administration's policy priorities, such as immigration enforcement, have expanded. Some efforts at regulatory repeal have also floundered. The prime example here was the failure, of course, of Congress to repeal the Affordable Care Act. But in addition, a number of the administration's efforts at regulatory repeal in the lower courts have failed. And it's also interesting that we now seem to have an active resistance by some agency personnel that has emerged over the last couple of years. Still, I think that the extent of anti-administrative and anti-government rhetoric in current politics is striking, and the resultant transformations in administrative governance under the Trump administration may very well prove quite significant. I'm actually, though, going to focus on an attack on administrative state coming from another quarter, and that is the Supreme Court under Chief Justice Roberts. The Supreme Court has turned notably anti-administrative of late, with justices raising questions about the constitutionality of longstanding and basic features of national administrative governance, such as congressional delegations of policymaking authority, administrative adjudication, and judicial deference to agency interpretations of their governing statutes and regulations. The Court has invalidated longstanding regulatory regimes on individual rights grounds as well, or required carve-outs, particularly on First Amendment basis. In what follows, I'm going to first describe these anti-administrative moves at the Supreme Court. I'm then going to identify some key characteristics that I think identifies why this falls into the camp of being united under the heading of anti-administrative. And then I'm going to turn to putting this contemporary anti-administrativism into historical context, in particular comparing the current moves to attacks on the Ministry of State that occurred in the 1930s at the beginning of the New Deal. And then finally, I'm going to argue that this Roberts Court anti-administrativism has the relationship between the administrative state and the Constitution fundamentally backwards. Rather than being unconstitutional, the national administrative state performs critical constitutional functions and, I'm going to argue, is in fact constitutionally obligatory today. So first, the emerging anti-administrativism at the Roberts Court. And the cases that I'm going to talk about that present challenges to national administrative government fall into several categories. To begin with, there are a number of cases that fall under the heading of separation of powers. In 2010, the Free Enterprise Fund versus Public Company Accounting Oversight Board case, for example, the Supreme Court there invalidated for-cause removal protections for members of an accounting board who were appointed to their positions by the Securities and Exchange Commission. According to the 5-4 majority opinion by Chief Justice Roberts, the problem was that because members of the SEC itself had for-cause removal protection, the result of having the board members also having for-cause removal protection was a double for-cause protection that eviscerated the president's control and denied him the ability to ensure that the laws be faithfully executed. One effect of free enterprise was to spark a cottage industry of sorts in structural constitutional challenges. One agency that's been at the center of many of these challenges is the CFPB, the new Consumer Financial Protection Agency that was created by Dodd-Frank. It is headed by a single director who serves a 5-year term and enjoys for-cause removal protection, and it is funded independently by the Federal Reserve. In a panel decision that was written by now Justice Kavanaugh, the D.C. Circuit struck down the structure, the one single director structure of the CFPB, arguing that the lack of a multi-member independent commission meant that there was too much accumulated power in single hands. And that decision was then overturned by the D.C. Circuit en banc, which upheld the constitutionality of the single director structure. But and that case was not taken up to the court. However, the CFPB structure is being challenged in a number of instances, and it's quite likely that that kind of challenge may come to the court, now with Justice Kavanaugh sitting on it. One of the things that you saw coming up in the opinions in free enterprise and also regarding the CFPB was the idea that the novelty of the administrative arrangements that were involved contributed to their being unconstitutional, right? This lack of historical precedent was an indication, in their words, of a severe constitutional problem. Interestingly, on the other hand, in the case involving recess appointments, which was Noel Canning versus NLRB, a majority of the court, in upholding a broad view of the recess appointments power, although not its use in the case at hand, the majority had emphasized the fact that there was a long tradition of this broad reading. But for a significant number on the court, many of the justices who were in the majority on free enterprise, the fact that the practice had been longstanding wasn't enough to shield it from constitutional attack. And so what you see there is just an asymmetry, right? Novelty is enough to condemn a new administrative arrangement, but a lack of novelty, the fact that it's rooted in historical precedent, isn't enough to save it. And that, I think, begins to give you a signal of the skepticism towards administrative government on the part of a sizable group on the Roberts Court. You saw that skepticism last term in a case called Lucia versus SEC, again, addressing very long-standing relationships about how administrative law judges were appointed at the SEC. New ALJs at the SEC were appointed by the chief ALJ as opposed to by the commission themselves. That's fine if ALJs are just government employees. It's a violation of the Appointments Clause if they are inferior officers. In Lucia, the court held that ALJs were, in fact, inferior officers. Therefore, this method of appointing the ALJs was unconstitutional, calling into question a number of decisions by the SEC and other agencies that had appointed their ALJs a similar way. This was an interesting case where the majority opinion was written by Justice Kagan, and she emphasized an earlier 1991 decision by the court as the basis for it. The reasoning in a concurrence, however, written by Justice Thomas and joined by Justice Gorsuch, would have gone much further. They advocated as a test for who counts as an inferior officer that would be whether or not you were performing an ongoing statutory duty. That test, if it were adopted, would mean that a vast swath of the federal government, of those who work for the federal government, would now be inferior officers. I'd wager that most, if not nearly all, of the people who would come under that definition are likely not to have been appointed in conjunction with the inferior officer clause, and therefore that kind of very broad reading would call into question a tremendous amount of the structures and officials and actions by the federal government. Given that this opinion was in the Lucia concurrence, I think we can expect that we will see more appointments clause challenges coming up the next few years as individuals try to get the court as a whole to adopt the Thomas and Gorsuch view. The Lucia case was also remarkable because of the stance taken by the Trump administration through the Solicitor General. The Solicitor General refused to defend the SEC, arguing that the ALJs had been unconstitutionally appointed, but he actually took the challenge a step further. According to the Solicitor General, not only was the mechanism for appointing ALJs unconstitutional, but so was their good cause protection from removal, and that unless that removal protection was read broadly enough that ALJs could be fired for failing to follow agency instructions and policies, then the removal protection was unconstitutional. The Supreme Court didn't reach this argument. It hadn't been in the case down below. It was added by the Solicitor General. But again, I think we will very likely see that argument coming up in challenges to the constitutionality of ALJ proceedings going forward. And it's worth noting that the removal protection that ALJs have dates back to 1946 and the Administrative Procedure Act that was adopted then that still governs in a fundamental way how the administrative state operates. And a central part of the Administrative Procedure Act was providing independence for administrative law judges against political control by agencies. So taking away that protection would be a very dramatic change to some very long-standing arrangements in how the federal government operates. Adjudication undertaken within the auspices of administrative agencies has been facing additional challenges at the court as well. In addition to the ones that I just mentioned, there have been arguments that when you have administrative adjudication and it's subject only to limited review in federal court, that this violates Article 3 of the Constitution. The constitutionality of administrative adjudication actually was settled early on at the beginning of the New Deal in a very famous case, Crowell versus Benson in 1932. Starting in 2010, the Roberts Court started raising some questions about what's called non-Article 3 adjudication. The case that they started raising these questions in actually was a bankruptcy case, Stern versus Marshall, famous because it involved the former model Anna Nicole Smith. But those questions have also extended to adjudication by administrative agencies. And it's currently unclear how far the Roberts Court is willing to take its pullback on non-Article 3 adjudication. This came up last term as well in a decision case called Oil States Energy Group versus Greens Energy Group. And the issue in oil states was whether or not an administrative agency, it was the Patent and Trademark Appeals Board, could constitutionally be given power to determine whether a granted patent should be revoked because the patent had initially been wrongly granted. By a 7-2 vote, the court upheld the power of an administrative agency to do that. Interestingly, written by Justice Thomas, who has not been so favorable towards administrative agencies, and you had Justice Gorsuch and Chief Justice Roberts in dissent. But the arguments in the case are actually what matters most. Both the majority and the dissent took an originalist stance in terms of deciding whether or not this form of non-Article 3 adjudication was constitutional. They just disagreed about what original practice had been. If originalism is going to be the lens through which we are assessing whether or not agency adjudication is constitutional, many instances of agency adjudication will fail because they do not have much basis back in the founding. A third form of separation of powers challenges or structural challenges that we're seeing have involved delegation. Now, congressional delegation of policymaking authority to administrative agencies has been called the dynamo, or alternatively the Energizer Bunny, which is my favorite, but you can take your pick, of administrative government. This reflects the fact that agencies have no inherent authority to act. Any power they use must come from Congress, or if it's an instance of exclusive presidential context of action, from the president. The court has sustained almost every delegation that it has seen going back to the founding. The only two exceptions are two cases at the very outset of the New Deal, both involving extremely broad delegations of authority under the National Industrial Recovery Act of 1933. Nonetheless, some cases have begun recently to raise questions about the constitutionality of delegation. The first was a 2015 case called the Department of Transportation versus the Association of American Railroads. This case should be of prime importance to Amtrak riders everywhere, which from my experience coming here today includes most of the people in this room if you're leaving Harrisburg by train. At issue was the statutory regime that Congress created to improve Amtrak's performance. And under the statute, Amtrak and the Federal Railroads Administration jointly established metrics and standards to judge Amtrak's performance. These are then also used to apply to the freight railroads who own the tracks on which Amtrak runs. And the freight railroads had challenged these metrics and standards as an unconstitutional delegation. The lower court had actually upheld this challenge. They had said that it was unconstitutional because it represented a delegation of power to a private entity. Amtrak is statutorily styled a nonprofit corporation, to set regulatory standards and that would also govern not just Amtrak, but also its competitors. Not surprisingly, when this went up to the Supreme Court reversed. And I say not surprisingly because the Supreme Court had, in a prior case, held that Amtrak, for constitutional purposes, is part of government. So the whole idea that this was a private delegation was a little odd for the court to go off on. But what was really surprising were the concurrences by Justices Thomas and Alito. And Justice Thomas's concurrence in particular was striking because he offered a very broad attack on modern-day delegations as fundamentally at odds with the original understanding of separation of powers. He argued that no delegation of policymaking authority to the executive was constitutional and that generally applicable rules binding on private conduct could only be established through legislation. This was a lone concurrence, but it was dramatic in its strong rejection of the basic structural principle of administrative government. Also, Justice Gorsuch has actually expressed sympathy with Thomas's attack on delegation when he was on the 10th Circuit. The real proof, though, of the court's willingness to maybe reconsider delegation is that it granted certiorari this term on a case, Gundy versus United States, which argues that a provision in the Sex Offender and Notification Act, also known as SORNA, represented an unconstitutional delegation. The provision at issue delegates to the Attorney General the power to determine whether and how SORNA applies to individuals who are convicted of sex offenses before SORNA itself was adopted. And the challenge raises both Justice Thomas's broad attack on delegation and also argues that this provision is unconstitutional under the existing delegation framework. Gundy was argued on the second day of term in October. We still do not have a decision, which suggests that it's going to be a hotly divided one. And I think, however the case comes out, whether the delegation is upheld or not, the very fact that the court granted the cert in this delegation case signals how much it is willing to question this basic feature of administrative government. So those were separation of powers challenges. That's the first category. Second category involves attacks on deference doctrines that govern how courts review administrative actions. The doctrines of deference to reasonable agency interpretation of the statutes they are charged with implementing, which are known as Chevron deference, at least to the administrative law students in the room, I hope are familiar to you. Chevron deference is a real mainstay of administrative law. However, it has been on the defensive for the last few years. Justice Thomas again has led the charge, attacking Chevron as violating separation of powers because it transfers judicial power to the executive, or alternatively because it represents an unconstitutional delegation of policymaking authority to the executive. Justice Gorsuch has taken a similar stance. So those are the broad-scale attacks on deference. We've actually seen more limited attacks as well. Chief Justice Roberts has sought to narrow the field to which Chevron applies. So he wrote for the majority in King versus Burwell, the Affordable Care Act tax credit case, saying that Chevron should not apply to questions of deep economic and political significance. Earlier, he had written a stinging dissent in the City of Arlington versus FCC, where he rejected applying Chevron to agency determinations of their own jurisdiction. Justice Kennedy, in one of his last opinions on the court, had a concurrence where he said that lower courts were deferring too much to agency interpretations. Although the court has yet to overturn Chevron or adopt one of these more radical attacks on it, to some extent they've already succeeded. The court has not, in a majority opinion, invoked Chevron and relied on it since at least 2016 and probably goes back to 2014. Parties in the court rarely invoke it, including the Solicitor General. And actually, in an opinion just issued last month, Justice Gorsuch approvingly remarked on this and said that basically Chevron was now no longer governing. So that's Chevron. Under attack, perhaps gone, unlikely, fully gone, but you can see where things stand. Another doctrine of deference where we see attacks happening goes under two names. It's called either Seminole Rock deference or Auer deference, and it involves deference to agencies' interpretations of their own regulations. The last time that our deference was sort of put forward by the court is a 1997 opinion unanimously, written by Justice Scalia, stating forward that, of course, we grant very strong deference to agency interpretations of their regulation. He changed his mind a few years before his death and actually started attacking our deference as at odds with separation of powers. It delegated power to the agencies to interpret their own rules, too much power in one set of hands, and also as a violation of notice and comment rulemaking requirements. You've had several other justices on the court echo those attacks. And again, the Supreme Court has granted cert and has on its docket, it was just argued last week, a case calling for our deference to be overturned. The case is Kaiser versus O'Rourke. And again, the Trump administration came in and although it was nominally defending some deference to agencies, actually agreed with much of the attack on our deference. A third category, so we've got separation of powers, we've got the deference doctrine. A third category of attacks on administrative government center on individual rights claims, particularly the First Amendment, right, requiring that either invalidating regulatory regimes or requiring carve-outs. Citizens United versus FCC involving corporation direct election contributions is one example. There were two cases last term, National Institute of Family and Life Advocates versus Becerra and Janus versus AFSCME. Becerra involved a California law that required pregnancy-related clinics to note the availability of a variety of publicly funded family planning services, including contraception and abortion, and to post notices if they weren't a licensed clinic. The court held that the law was a content-based regulation of speech that violated the First Amendment. In Janus, the court similarly upheld the First Amendment challenge to a state regulatory scheme. This was the agency fee scheme that basically said if you don't want to be a member of a union, you don't have to be a member of the union, but you can be required to pay, this is for state employees, you can be required to pay an agency fee that would cover the union's collective bargaining services and representation services. Such agency fee requirements had been longstanding. They had been upheld as constitutional by the court in 1977, but Janus now ruled them unconstitutional and shows, I think, the extent of the court's willingness to overturn longstanding regulatory arrangements on free speech grounds. You also see the court entertaining free exercise claim to regulatory regimes. Last term, there was a case on that, too, the Masterpiece Cake Shop case. There, it was a free exercise challenge to a public accommodation, state public accommodation statute. The court managed to avoid a full-on challenge by essentially saying that the Colorado Civil Rights Commission had engaged in intentional discrimination. But that's definitely an area where we're going to see challenges coming to the court in the future, and most likely the Roberts Court seems to be sympathetic to them. So these are three categories of cases that I think represent a significant attack on the national administrative state at the Supreme Court. There are, to be sure, instances where the Roberts Court has rejected challenges to administrative power. They upheld the Affordable Care Act in NFIB versus Sebelius, although, of course, they also rejected the Commerce Power Basis and rejected the Medicaid expansion. So that's not really a full-on endorsement. They have not been so sympathetic to efforts to assert individual economic rights to regulatory schemes. Those have not yet reached much appeal. Still, the point is that it's not that the court is striking down all regulatory action across the board. That said, the trend of these three categories is striking, and there are some commonality to these challenges that, to my mind, justify their linking as part of a distinct and emerging trend on the court of what I call anti-administrativism. These three traits, the first one is a rhetorical and almost visceral resistance to administrative government portrayed as running amok. Bureaucratic bashing in the political sphere is nothing new, but it is unusual to find it in Supreme Court opinions. Some of the language is actually quite strident, so let me give you a flavor. Some choice quotations from Chief Justice Roberts. In Free Enterprise Fund, he described federal agencies as representing a vast and varied federal bureaucracy that now wields vast power and touches almost every aspect of daily life. He was even more evocative in City of Arlington, stating that the danger posed by the growing power of the administrative state cannot be dismissed. The citizen confronting thousands of pages of regulations promulgated by an agency directed by Congress to regulate, say, in the public interest, can perhaps be excused for thinking that it is the agency really doing the legislating. And with hundreds of federal agencies poking into every nook and cranny of daily life, that citizen might also understandably question whether presidential oversight is always an effective safeguard against agency overreaching. Two distinct and overlapping but distinct concerns about executive power emerge from this rhetoric. One is that the power is unaccountable because bureaucrats are not elected or subject to meaningful political oversight. The other is that executive power is aggrandized and ever expanding. These concerns, although overlapping, suggest different remedies. Ensuring accountability might call for greater presidential oversight, but expanding presidential control over administration might worsen concerns about aggrandized power. As a result, the anti-administrativism coming from conservative quarters today is different from the unitary executive theory that conservatives traditionally espoused. Instead of turning to the president, the common response to these fears of unaccountable and aggrandized power is an assertion of a greater role for Article III courts. This judicial turn is the second trait that I see in contemporary anti-administrativism. It is most centrally manifested in efforts to replace deference with judicial independent judgment, and you see frequently that the attacks on judgment, on deference, come accompanied with an invocation of Marbury and the statement that it is emphatically the province and duty of the judicial department to say what the law is. Now, protecting a role for the Article III courts has always factored into deference doctrines. That is why deference only applies once a court has found a statute to be ambiguous, right? But we are now seeing an extreme argument to the effect that any deference at all violates the court's constitutional role. A third trait, a theme that you see in contemporary anti-administrativism is the heavy constitutional flavor of the attacks on the administrative state. Sometimes statutes are invoked. Sometimes you get the argument that deference is at odds with the Administrative Procedure Act, for example. But overwhelmingly, the thrust of these attacks sound in a constitutional register. And while separation of powers concerns have long animated administrative law, usually they have lain in the background. And now these constitutional concerns are really front and center. Moreover, these constitutional complaints are often presented in originalist terms. The problem with the administrative state is that it makes it easy for the government to bind individuals, whereas the framers intended that to be hard. Alternatively, the administrative state is seen as combining different forms of power into single agency hands, whereas the framers sought to separate out different forms of power into the separate branches. Now, in my view, these constitutional attacks are not successful. Even if you accept the originalist focus, many features of the administrative state that are deemed unconstitutional, such as deference, in fact, go back to the founding. Equally important, critics portray separation of powers as simply aimed at limiting government, but in fact, the framers had multiple goals in setting up the structure of the federal government. And they also sought to build up the national government and make it more effective. In addition, concerns about too much accumulated power can be achieved through mechanisms that operate at a subconstitutional level, for example, separation of functions requirements, bias protections, other mechanisms, as opposed to a pullback on the administrative state itself. Plainly, however, a number of justices on the Supreme Court feel differently than I do, and they increasingly portray the national administrative state as fundamentally unconstitutional. So that is a description of contemporary judicial anti-administrativism. How important a phenomenon it is remains, I think, an open question. As I hope my description conveyed, we're seeing in some of the claims that judicial anti-administrativists are advancing, they come in more radical and also more moderate forms. Many of the more radical versions of these attacks come in concurrences or dissent and have not yet achieved a majority of the court. We are still waiting to see if a majority will sign on. I think that this term will be a good sign of how far this is going to go. Even, however, if this anti-administrativism yields limited invalidations or remains mainly in concurrences and dissent, I think it is a significant phenomenon. I think to begin with, some invalidations that seem limited, like you have to appoint ALJs differently in Lucia, can have some significant disruptive consequences for how the administrative state operates. Similarly, the presence of deference doctrines, people say it doesn't really matter if you get rid of Chevron. Maybe, but having Chevron there actually affects the kinds of cases that are presented. And so even if there aren't that many cases that would change in terms of the cases we see now being brought with Chevron in the background, once Chevron is gone, we might actually see significantly more. More importantly, I think that this judicial anti-administrativism, particularly combined with the kind of attacks on administration and administrative government we're seeing from the White House and from parts of Congress, actually serve to undercut the legitimacy of the national administrative state. The frequent suggestion that that national administrative state is unconstitutional, along with the kind of rhetorical invocations against abuses of power-hungry bureaucrats, serves to call the state's legal, moral, and political legitimacy into question. Now, a contributing factor here is the extent to which discussions about government and administrative power have permeated popular debates, in part a reflection of the deep political polarization of our times. In the past, I think a discussion of the proper constitutional metes and bounds of administrative government might have been more reserved for a more elite or legal discourse. Today, however, I think the popular engagement with these matters is far broader. Popular debates about the existence and dangerousness of the deep state, for example, showcase this. And I think that this identifies how the kind of anti-administrative rhetoric that we're seeing can take on a life of its own. There are two further effects of judicial anti-administrativism that I want to flag. One is the effect that it has on public views of the court, and the other is the impact it has on constitutional law. I think that the anti-administrativism's deeply rooted conservative character means that constitutional attacks on the administrative state risk injecting the court even further into national politics, and by insistently framing the debate as centering on the administrative state's unconstitutionality, anti-administrativism ignores the constitutional benefits that the administrative state can bring. To explore these 2 points, I'm now going to talk about how the current attack on administrative government connects up to the attack we saw in the 1930s, and then at the end I'll talk about some ways that we could see the administrative state as being constitutionally beneficial. So anti-administrativists often identify the progressive era, from the late 19th century through to the early decades of the 20th, as the time at which the national government went off the constitutional rails and over to the dark side of administrative government. Given those earlier progressive era measures, FDR's election in 1932 and the enactment of the broad regulatory statutes of the New Deal were not a sudden birth of national administrative government, but they did represent a significant intensification. The forebears of contemporary anti-administrativists are the business conservative forces who took on the New Deal and the expanding administrative state in the 1930s. Many businesses were actually quite supportive of FDR and of national economic intervention to address the Depression at first. The National Industrial Recovery Act, in particular, they supported, with the suspension of antitrust laws and its reliance on business-developed fair codes. This support began to sour, however, pretty quickly as protections for labor also emerged as part of the New Deal. There were 2 organizations that were central to business efforts to challenge the New Deal. One was the American Liberty League, and the other was the ABA Special Committee on Administrative Law. The Liberty League was the brainchild of several major industrialists, in particular the DuPont brothers, who ran the giant chemical and plastics company of the same name. The League claimed to be nonpartisan and had well-known Republicans and Democrats as members, but what did unite them all was their deep conservatism and antipathy for the New Deal and FDR. FDR then ran against the League in 1936 and won a landslide victory, at which point the League essentially folded and went out of business. But while it was active, the League published many pamphlets that attacked the New Deal on constitutional grounds, criticizing broad delegations, criticizing executive orders, warning of unlawful administrative assertions of power, and of expanding bureaucracy. And the League regularly turned to lawyers to make these constitutional arguments. It created a national legal committee, the NLC, which was composed of many of the leading business lawyers of the age, which wrote reports condemning major legislation like the National Labor Relations Act as unconstitutional. And then these reports were popularly condemned as serving the interests of the NLC members' business clients. Several of the League's lawyers and the NLC lawyers also argued constitutional challenges in the Supreme Court. So they filed brief in cases such as United States versus Butler, which challenged and overturned the Agricultural Adjustment Act, Carter versus Carter Coal, which challenged the Bituminous Coal Conservation Act, NLRB versus Jones and Laughlin, which challenged the NLRA and was the turning point when the court upheld it. This constitutional assault on the New Deal actually had found a certain amount of favor up until 1937, but then hits a wall. The tides quickly turn, and within a few years, constitutional limits to economic regulation and national administration had largely disappeared. The ABA Special Committee, on the other hand, it was distinct from the League, but there was significant overlap between the members of the NLC and the members who were leaders of the ABA at the time. The ABA Special Committee also proclaimed neutrality on New Deal policies, but it was repeatedly expressing concern about the spreading expanse of national administration. Interestingly, unlike the League, the Special Committee really focused its attention on advocating for reforms to administrative process and to increased judicial review. The Special Committee was actually, in the end, much more effective than the League. The Special Committee was behind a bill, the Walter Logan Act, which passed Congress but was vetoed by FDR in 1939. But the committee's influence continued to be felt, and ultimately it was the legislation that the head of the Special Committee helped author that was enacted into law as the Administrative Procedure Act in 1946. Again, as I mentioned, that act continues to govern the federal administrative state to this day. 8 decades on, the national administrative state has expanded substantially from these New Deal and progressive roots. The 1960s and 1970s marked the addition of Great Society programs like Medicare and Medicaid, as well as new social regulations in terms of the environment, consumer protection, worker health. And there have been other recent additions, financial regulation, right? Health insurance are too. Despite these changes, I think that the Special Committee and the Liberty League offer instructive parallels for understanding and assessing contemporary anti-administrativism. The 1930s represents the first and the last time that national administrative government was subject to the type of sustained constitutional challenge that we are seeing today. Strikingly, many of the current constitutional attacks are made in terms identical to those raised by the League. In addition, many of the legislative initiatives that we're seeing, like the Regulatory Accountability Act, are very similar to the kind of legislative moves that the Special Committee adopted. Recognizing contemporary anti-administrativism's connection to the failed challenges of the 1930s thus recognizes its radical potential. If accepted, contemporary anti-administrativism's claims would require a reformation of the constitutional order that has governed for the last 80 years. The League and the Special Committee are equally important in highlighting the role that business leaders and conservative forces have played and continue to play in fostering resistance to national administration. To be sure, we often find today business leaders are at the forefront of pushing some regulatory initiatives, such as protecting civil rights. And anti-administrativism, when you look at it and you look at the conservative underpinnings, reflects many different forms of conservatism, not just business conservatism. Yet it remains true that the business and economic conservatives who were critical in developing the New Deal attack on the newly emergent administrative state, and they were joined by the elite lawyers of the day. It was also business and economic conservatives who continued to resist the national administrative state after World War II. In 1971, soon-to-be Justice Lewis Powell penned a famous memo to the Chamber of Commerce calling for a litigation strategy to defend business interests, spawning a birth of conservative legal organizations that are described as fulfilling the vision of the Liberty League. Today, business interests are closely tied to contemporary anti-administrativism. They are behind the regulatory rollbacks in the Trump administration and in Congress. Groups like the Chamber of Commerce and the National Federation of Independent Business frequently participate in litigation challenging administrative action, and a network of business lawyers often appears in the current attacks as occurred in the New Deal. The parallels to the 1930s are perhaps nowhere stronger than with respect to Charles and David Koch, the modern-day equivalents of the DuPont brothers. The Koch brothers' funding extends to a wide range of organizations associated with contemporary anti-administrativism, from conservative political organizations like the Tea Party to conservative think tanks like the Heritage Foundation to conservative academic centers studying the administrative state. In short, as was true in the 1930s, business conservative support has been critical to the growing prominence of contemporary anti-administrativism. The League and the Special Committee are significant also in demonstrating the inescapable political aspect of the current attack on administrative government. Despite the fact that the League wrapped itself in the Constitution, no one doubted the political and economic interests that motivated its members. And as against that 1930s background, the current attempt appears as simply the latest in a series of conservative attempts to rein in national administrative government. To acknowledge this political character is not to deny conservative anti-administrativism's genuine constitutional concerns. It is instead to deny the separability of politics from efforts to mold the constitutional contours of the American state. But this inherent political overlay poses a particular challenge for contemporary anti-administrativism in the Supreme Court. Even if clothed in constitutional garb, judicial efforts to cut back on administrative governance will inevitably be seen in political terms. That is a particular concern when the Roberts Court is already perceived as heavily politicized and conservative due to recent appointments and fraught confirmation battles. There is thus a danger that if the court were to follow through on its anti-administrative rhetoric and significantly cut back on the administrative state, they will do long-lasting harm to the court's institutional legitimacy. Here, the 1930s are even doubly instructive, just as we are now seeing calls for court packing in response to the recent confirmation battles. Of course, the major instance of threatened court packing was in the 1930s by FDR in response to the court's resistance to the initial measures of the New Deal. So this leaves my third and final topic, the effect of anti-administrativism on constitutional law, and I'll be briefer. As I described, you see at the core of this contemporary anti-administrativism is an attack on constitutionality of administrative arrangements, right? It is portrayed, as I mentioned, as unaccountable and aggrandized executive power. I think anxieties about executive power are perfectly understandable today in our era of growing presidential unilateralism. Presidents are the focus of national political life and expectation, giving them incentives to expand their power in whatever ways they can. And one of the main levers that presidents have to exploit is their control over administrative government. As a result, presidential control over administration has become the dominant characteristic of national government. And they increasingly use that power not just to advance their policy priorities, but to advance those priorities in the face of a dysfunctional Congress. So I think concerns about expanding executive power have a real basis. But I also think that the attack on the administrative state gets the constitutional logic here exactly backwards. And that's because the administrative state performs critical constitutional functions. It is the administrative state, with its bureaucracy, expert and professional personnel, its internal institutional complexity, that holds the key to securing accountable, constrained, and effective exercise of executive power. Consider first the managerial oversight and supervision that runs throughout the administrative state and is sort of the classic characteristic of bureaucracy. This supervision is essential to ensure that low-level personnel are following politically determined policy and that important information about administrative activities reaches the highest level of political officials. To put it differently, it is bureaucracy and supervision that allow the president to take care that the laws are faithfully executed and that allow Congress to perform its constitutional role in setting national policy. Such internal mechanisms of control are also critical for achieving legal accountability. They reach a far broader array of agency action than judicial review ever can. Moreover, these mechanisms work proactively, helping to prevent unlawful actions from occurring in the first place and ensuring that governmental power is exercised within legal limits. Equally important are the variety of forces and interests within the administrative state that often operate as a check on one another and that preserve the rule of law. Career officials, such as executive branch lawyers, are a particularly important force. Their civil service protected status provides some independence, and they often feel bound by legal and professional norms that guard against abuse of authority. Agency structures reveal further internal divisions and checks on administrative decision-making. Examples include separation of functions requirements that help guard against bias, internal watchdogs like inspector generals, or the fact that you often have multiple agencies bringing competitive perspectives to play in different statutory schemes. These internal administrative constraints embed separation of powers values into the very fabric of administrative government. They guard against excessive presidential aggrandizement by diffusing power throughout the executive branch, and they foster deliberation by bringing a range of perspectives to bear in setting executive policy. These internal forces also help empower external checks on the executive branch through the expertise and information that they provide to Congress and the network of relationships they have with Congress, states, and non-governmental entities. By thus supervising, checking, and improving executive branch decision-making, the administrative state performs important constitutional functions. But probably its most important constitutional function is that it empowers and provides the means for effective governance. It brings that expertise, specialization, information, and institutional capacity to bear on complicated policy questions. Although anti-administrativists focus on the danger of too active government, an executive branch that fails to effectively perform the responsibilities that Congress has assigned to it should be equally troubling. Achieving energetic and effective governance was an express and central concern of the framers in designing national government. It is also essential if we are going to achieve responsive and democratically accountable government today. Interestingly, defenders of the administrative state in the 1930s, just to go back to the 1930s for a moment, justified it expanding administrative government on grounds very similar to the ones I'm articulating here. The Brownlow Committee, a committee on administration and management that FDR established, emphasized the importance of hierarchical supervision. James Landis's famous The Administrative Process defended the administrative state in terms of expertise and combined powers. Both urged the need to expand the civil service, and both argued that energetic government is critical. Right. So again, if you look back to the 1930s, we can get some important insights. Not only does the administrative state play a critical role in cabining and effectuating executive power, I want to close with the thought that the national administrative state is today constitutionally obligatory. And the reason it is because of delegation. Constitutional delegations of authority to the executive branch date back to the founding. And as I mentioned, they are the backbone of administrative government. Despite the Gundy case that's currently before the court, I do not think that the court is going to do away with delegation. But I think delegation comes with significant constitutional strings attached. One consequence of delegation is a constitutional need for adequate administrative and oversight capacity to allow the laws to be faithfully executed. That means sufficient expert personnel to implement delegated statutory responsibility. It means sufficient administrative resources to implement statutorily delegated responsibility. And delegations may also entail the kinds of internal structural checks and constraints that I have described to guard against the risks of executive branch aggrandizement that those very delegations create. In addition, delegations may entail deference in order to do justice to Congress's choice to give certain decisions to administrative agency. One of the unfortunate effects of contemporary anti-administrativism is not just that it obscures the administrative state's constitutional benefits, but that it makes this suggestion that the administrative state is constitutionally required seem quite outlandish. By insisting on reviving the constitutional challenges of the 1930s, anti-administrativists are forestalling the development of a separation of powers analysis that is better tailored to the reality of our current government. Such a 21st century account of administrative government is possible, however, if we put the blinders of contemporary anti-administrativism aside. Rather than laying siege to the administrative state, such an analysis would seek to maximize the constitutional benefits that it has to offer. And it would reorient separation of powers analysis to considering not just constitutional constraints on government, but also constitutional obligations to govern. Hopefully that is a task that administrative and constitutional law scholars will embrace going forward. Thank you.
Widener University Commonwealth Law School is the Pennsylvania capital's only law school, with 3 specialized centers of legal scholarship through its Law and Government Institute, Environmental Law and Sustainability Center, and Business Advising Program. Widener Law Commonwealth offers an exceptional learning experience that is personal, practical, and professional. Visit commonwealthlaw.widener.edu for more information.